Hi everyone, and welcome back to our vlog series. I'm Margaritha Windisch, a PhD student at ETH Center for Law and Economics, and in today's episode, I have the pleasure to talk to Laura Pedraza-Farin. She's a professor at Northwestern Pritzker School of Law and also a faculty affiliate of the Science and Human Culture program at Northwestern University. Your research falls into two main areas, innovation law and policies, and also international organizations. And today we will talk in particular about your work on network theory of patentability. And there you take a novel approach to answer what non-obvious invention is and also how to determine non-obviousness in specific cases. So why don't you tell us a little bit more about the background of the paper and also the paper itself?
Sure. So in this paper, me and my co-author, Ryan Whalen, we look at a new model for understanding how innovation happens, a new model based on network theory. I'm using that model to then help shape a really key doctrine in patent law, which is the non-obviousness doctrine. So I think it would help if I just tell you a little bit, okay, what is non-obviousness in patent law, and then how our model can help clarify the doctrine. So the non-obviousness doctrine in patent law has been called the gatekeeper of the patent system because its key role is to basically differentiate inventions that should get a patent from inventions that should not, right? And the sort of way to think about it is that you're trying to give patents to inventions that represent a significant enough leap in technology and not give patents to inventions that would happen in the regular course of business. So this seems like a sort of simple proposition, but it's been really hard for judges to operationalize this. So how do we create a legal test that can actually differentiate obvious from non-obvious inventions? So courts have struggled for many years to figure out a standard for non-obviousness. And in our paper, we say, well, one of the reasons why courts have struggled is number one, because there's actually two theoretical ways that courts think about non-obviousness. Courts sometimes think about it as a psychological process. So what we're trying to understand or identify are leaps in creativity, right? So very creative inventions are inventions that deserve a patent. And to do that, you ask judges to put themselves in the shoes of an ordinary inventor or an ordinary artisan or a member of that innovation community and see if that person would be able to cognitively come up with the invention, right? There's also an economic way to think about non-obviousness, which is basically the idea that we don't want to give patents to inventions for which market forces are sufficient, right? So if the market can bring about an innovation, you don't need a patent for that innovation. Another way to put that is that you want to give patents for inventions that, but for the patent, would not exist. And so those two theoretical ways of understanding non-obviousness have led to a certain amount of confusion in terms of what the best doctrinal test for non-obviousness is. Our proposal says that a very important but overlooked way to look at non-obviousness is to first take a step back and start with a theory of innovation. So we propose a theory of innovation that's based on networks that basically says the way that innovation happens is in communities of innovators. Those communities are spread across the knowledge space. And you can imagine innovation taking place as a process of search and recombination. One community searches for information and recombines known with unknown information to create an innovation. We also know that knowledge that is far apart in a network, either because it's cognitively distant or because it's housed in socially distant communities, is actually risky and hard to recombine. So what we propose is a model in which patent law should reward inventions that make long searches and recombinations, also recombine distant knowledge, and should be very skeptical or look more carefully at innovations that are simply recombining local knowledge. So this contribution we turned this contribution to an empirical measure. So we created a new measure of patentability, which is called the Network Non-Obviousness Score, that measures especially that, right? So it measures how far apart or how close together is the knowledge that every individual patent recombines. And again, if a patent recombines knowledge that is far away, we say you should put a thumb on the scale towards patentability, because many breakthrough important innovations arise by recombining knowledge that is far away. And this is risky research and research that should be incentivized.
Thanks for the brief summary. And where do you see the advantages of the network approach to patentability you take?
Right. So there's several advantages over current approaches. One caveat that I would want to say first is that we don't think a network approach replaces all tests for non-obviousness. So we think the network approach can be useful, especially as a sorting mechanism. So let's say a patent comes to the patent office, and the patent office needs to figure out, do I need to look at this patent very carefully? Is this patent that where we should have a presumption that it should get a patent, right? And so there we say this network non-obviousness score can be a really quick and quite objective mechanism to sort of sort inventions that we think are have a potential of being breakthrough, or have a potential of recombining areas of knowledge that are far apart. Those inventions, we argue there should be a presumption that they are non-obvious, right? So inventions that recombine really far apart areas. Of course, that presumption can always be rebutted. At the same time, if you have an invention that's recombining areas of knowledge that are very often recombined, then look at that invention more carefully. So that's one way in which our measure could help. Another way in which our measure helps is that in the beginning, I mentioned this clash of different theoretical frameworks, right? There's a psychological framework and an economic framework. One important thing that judges are very worried about, in particular in the cognitive framework, is to think about the problem of hindsight bias. And the idea is that if we're asking somebody who already knows the endpoint, right? They already know the invention. If we're asking them to figure out if that invention would have been obvious in light of the prior art or the prior knowledge, there's a risk that we will think a lot of things are obvious that wouldn't have been, right? So it's a temporal problem, right? It's really, really hard to travel back in time to the point of the invention once you already have the finished invention in front of you. Our network measure can address that, right? Because we can actually come up with a network non-obviousness score at any time. So we could travel literally back in time to the time of invention, for example, and look at the frequency by which two areas of technology are recombined in that particular time point. So for any patent, the network non-obviousness score will change over time, right? And we can fix it at a particular point in time. So an invention that may be obvious now actually might not have been obvious at the time of invention, and that's the relevant time from a legal perspective.
And where are the limitations of this approach? Like also, for example, in your model, where are the challenges, and also how do you deal with them, for example, regarding biased data inputs or measuring design?
Yeah, no, that's an excellent question, and something we struggled with in the paper to make sure we made it clear that this was not the measure or even the best measure for the theoretical concept, right? So we should separate the sort of the theoretical concept or idea, right, that that measures of distance between knowledge communities are important to understand whether an innovation is risky, and to understand whether an innovation is likely to be a breakthrough innovation, right? So that would be the first takeaway, right? That from a theory perspective, these network concepts of distance are important. They should be incorporated in patent law. Then how do you operationalize it, right? And there is where it becomes tricky. And I would say our score is a proof of principle, right? So the way that we do our score is we take individual patents, right? And we look at the technology areas that the Patent and Trademark Office assigned to each patent. And then we take pairwise distances. We take every two categories and we put them together. And then we see how often those two technology areas have been recombined in the past, in the set of all the patents that came before. And then we make the choice of taking the longest distance, right? So the longest distance between two categories is what we take as our score. You could imagine all sorts of potential problems and concerns with that measure, right? One of them has to do with complexity, for example, right? So you could have an innovation where any two pairs of technologies are medium size apart, right? Under our score, that would not be a sort of a breakthrough innovation. It wouldn't have a very sort of good network non-obviousness score. But if it's a complex innovation that combines multiple technology areas, it perhaps is the type of innovation that also should be considered potentially breakthrough, right? So I would to say it in a different way, right? Our score doesn't take into account complexity. You could think of other scores that could, right? You could think of other scores that could not just take pairs, but could take into account how many technology areas are being recombined, right? You could also think about scores that are designed in different ways, right, to get at the same concept. For example, you could look at teams. So you could look at the inventors, right, and try to figure out, are the inventors coming from different disciplinary homes? And you can do a map of the inventors. You could also do a map looking at the prior art and where the prior art is close to the references are close to each other or far apart. So you could operationalize this in a lot of different ways. And our suggestion is that, again, this paper should be a proof of principle, that you can do it and it can yield interesting results for patent law, but that the best measure is probably a measure. There's not a best measure, actually. That the best thing to do is to have multiple measures, right, that you could use at the same time. And if all the measures coincide, there you have a really strongly, potentially non-obvious invention.
And what impact should the network non-obvious score have on the future of patent law and also regarding innovation policies?
Yeah, so our hope is that the patent office and down the line potentially courts will sort of warm up to this sort of more quantitative signpost for patentability, right? So there's so much research that's done on all sorts of areas: sociology, economics, business, of innovation, right? Like we know a lot about the context of breakthrough innovation, and a lot of that research does not get translated into doctrine and into judicial decisions. And I think our measure is one small way to get that research to actually have a doctrinal impact. So we hope that the Patent and Trademark Office will look at this idea seriously and think about incorporating network measures. And it doesn't have to be ours. We're not saying our measure is the best one, but think about incorporating network measures when they're looking at non-obviousness, which is a really tricky and but also key area of patentability that basically determines in many cases whether somebody gets or doesn't get a patent. And it will make non-obviousness less murky and more objective, which I think would be a great advance for the patent system, and especially in the US, but I think that this is true all over the world. Non-obviousness is a global doctrine, but where there's been a struggle and there's been a big debate about patent quality, right? So I think adopting some of these measures and some of these theories of innovation would go a long way towards improving patent quality.
Thank you for joining our vlog series, Laura. Thank you for your time. And to our vlog viewers, we hope you enjoyed this episode as much as we did. And if you want to know more about the network theory of patentability, check out the paper from Laura and Ryan in the comments. See you next time.